And we're live. Thank you so very much for joining me. You've got your Omi Inca live coming at you from Omi Inca's production studio. And our topic for today is what can a case fall apart? And what are some of the resolutions to solving the case? And we're going to be talking about a mock case and trying to give you some insights to anyone that might be going through themselves, anyone that might have gone through an EEOC charge, been a part of a class action case, somebody that might know something about the courtroom and what actually happens there. Okay, give me a minute here. Gotta go and take something out of here. So just hold tight. Gonna be okay. Now, as I was saying that our topic is, can a case fall apart? And what are the resolutions for solving it? I think a lot of people who have not been in a courtroom and probably have not really had a chance to see what the judge does in family court. I'm a little bit familiar with family court. I don't know what that is. I'm a little bit familiar with family court, and I have been in many courtrooms. And from my perspective, and this is just my hunch, I'm going to be discussing bits and parts of my case that I had where I was in and out of court. But let me repeat that again. Can a case fall apart? So we're going to take this apart. And I'll take that particular phrase first. Why, yes, a case can fall apart. And they have fallen apart, many of them. I had a case that fell apart. When you have a large number of people engaging in the case who were solicited for clients who alluded to that they were a victim, you get a large number of people that you lose continuity to controlling. And when you first start off with nursing that lie or start off with fabricating stories, the stories, they diminish little by little. And when you're no longer around, each time that person tells that story, it changes. And eventually, those stories deviate from what the courts wanted to hear. It might be one thing one month, and next month it'd be a whole different thing. And then you know you can hurl them out as plagiarizing themselves while under oath. And one of the things that I wanted to say is that cases do fall apart. You can bet on them. And in the case of R. Kelly, there's a great potential that that case will not solidify. It will begin to fall apart little by little. You don't have to coach anybody. You don't have to say anything. They'll begin to fall apart because whenever there is money involved, money changes things. And when someone flashes money in front of your face, your whole idea of the truth changes. And I want to say that we have a basing their whole character off of what they appear to be, not what they actually are. And that means that a lot of people will take money in exchange for a lie. And it's so sad that a large portion of our African American families who are dirt poor or who are struggling to get by, they think that this will give them a chance to get on their feet. Usually it's an opportunity to open up the door for more problems. So let me give you a little bit of insight about what I'm talking about personally. I can speak from a personal perspective because my case is over and I can speak about it. There are many people that are in employment positions who've been discriminated against, and they're afraid to go at it alone. And sometimes when they get enough momentum in a department where there are more than one or two people experiencing the same problem of racism or discrimination, there have been times when women have gotten together, whole departments have gotten together, and they've brought a case. And sometimes that case can be called a class action case. Now, I want to tell you this so that you'll know for the record. A class action case is very, very difficult to prove. First of all, they want you to prove typicality and commonality. Is it typical in that area for minorities to be discriminated against? Is it typical, and is this a common thing that happens within that type of industry? And first of all, before you can even bring a class action case, you must get it approved, and they must find that you have actually laid a foundation for typicality and for commonality. And if those two things are not proven, they will not approve your case for a class action case. You could be right on the money. You could have all the documentation, and you can have all the people lined up with their cases who want to tell their story. But if it doesn't prove typicality and commonality, they will throw out the class action, because they will say that you cannot prove discrimination for a class of people. And even though you know that a class of people have been discriminated against, that case will not go forward, at least in governmental cases. Now, if that case is not proven to be a typical and have commonality to be brought as a class action, then the judge usually will pick one of the more convincing individuals or victims in the case that he wants to pursue and go forward with their individual case. Now, I was fortunate that my individual case was selected to go forward. And bringing that individual case forward means that the other people drop off. So you're kind of like by yourself. Now, a number of things can happen when you're gathering facts. You have the EEOC department that by law is deemed required to go out and do the investigation and gather the facts, just the facts. Gathering the facts usually is something that a mediator does, who attempts to try to gather the facts to bring them back to the two individuals, the defendant and the plaintiff, to address those facts and lay those facts out so that the hearing officer, and they're usually with the EEOC case, there's not a judge involved, but a hearing officer when you first start. So therefore, these courtroom cases are held in offices when they first start. But in gathering the facts, they're hoping that you can resolve the case at the mediation stage. And what that means is that you begin to mediate, and the facts are presented. What are the facts? Who said what? Who did what? Who were the victims, and who was discriminating against who? And were there any statements made? And if there are already allegations that are being placed against an individual, those allegations has to be proven right or wrong right up front. So the EEOC officer goes out and interviews a community of every one of those alleged violation of misconduct, is what they call it. So in essence, 9 times out of 10, when that EEOC officer goes out there, they have to hunt for those people that were in the allegations. Who were they? And can I schedule the time to speak with them to get their story? They sit down with the EEOC officer, and the EEOC officer collects facts and information and tries to get their point of view as to what happened. And if that allegation was completely a lie, and the person that they interview come out and say it was a lie, it never happened, it gets documented. Now, if something about that situation, around that situation, was distorted and it happened, but it didn't happen in the manner that it was reported, then the EEOC officer also gathers those facts and records that. But if that particular interviewer would like to make a statement in writing, they also oblige them by collecting any statements that they want to make in writing. And sometimes it's to the defendant's better judgment for them to make a statement, because it goes in writing and it becomes a document, an exhibit that you can actually reference to in your case. Now, I've seen where so-called alleged individuals who are testifying will lie up under oath, and if they have been persuaded or offered funds and monetary gain, sometimes they take those funds and they still lie. So those who will be honest and tell the truth up front, it makes it a lot easier to go through the investigation. But mediation is a period where they're collecting facts. They cannot make any decision at that stage, because they are just the mediator who collects the facts. After the facts have been collected, they're brought back to the hearing officer and the defendant and the defendant and the perpetrator, well, the person the plaintiff, and they're brought back. And during that particular time, they talk about resolving the case at the mediation stage. And the facts may be so miscrewed, or the facts may be so distorted that the person may still be lying who alleged these particular allegations, and she may have not gotten enough facts to prove those allegations to be wrong. And then again, it could be just the opposite. Maybe all of the allegations were overturned. And if they are overturned, then that particular hearing officer can allege that somebody lied up under oath and they didn't tell the truth. Now, but that particular mediator who has collected the facts cannot make any decision. It then goes to the arbitrator, and the arbitrator will look over all of the allegations and the facts and start to put the pieces together to iron out just who is lying and who is telling the truth. And that arbitrator can, in order to resolve that issue, can offer or suggest that a settlement be made, because they have overturned all of the allegations and they were proven not to be true. And it will be to that individual's benefit, because now every one of the allegations have been overturned, and it was found that those false allegations were solicited for. And so no one wants to admit to any guilt. No one will say, well, we have discrimination in our department and we're guilty. They will agree to settle, but without admitting to any guilt or any person doing some ill preparation or doing some ill racist things. So in a case like that, they offer to settle in order to prevent from being found out that they were guilty. And when they offer to be settled, you have to be very, very careful, because in that room, that courtroom where they offer to settle, things change. And they could be one amount 1 minute, and then the next time you see them is a different amount. And An offer could be put on the table that everyone agrees to. And then when the attorneys come in to sign off on it, the attorneys also can throw a monkey wrench. They may say, oh, but you deserve much more than this, and I'm going to see if I can get it out of them. Now, if the other party has offered a settlement without any counters, no counters whatsoever, no changes, and if that lawyer walks in there and say, well, oh, they don't mean that, I'm going to get more money out of them. And if he offers a dime more and stand his ground and say that we want 10 cents more, at that particular point, the other defendant can say to the plaintiff, we said without counter, and they can take the offer off the table altogether. Now, let me get back to R. Kelly's case. In a situation where you have families, lots of families, it becomes a family law issue. And I wouldn't be surprised if this case wouldn't be submitted to the family law department, because we have a situation where a guardian ad litem may be requested to address the family's issues, to address the girls' issues. Now, if that is the case, and they bring in a guardian ad litem, the question would be, when those girls were underage, if it was found that their parents were soliciting for these underage children to participate in any sex act or any bedding, then they could truly be held accountable for those underage girls. And they could be tried because the girls were not at the right age of consent to be an adult. Now that they've gotten older, I don't know what the case may be, because they are consenting individuals and they are grown. So I don't know what may happen now that those girls have outstayed their welcome, and they're over 21. But prior to them being 21, just like any child is removed from the home when they expect an abusive situation, and that was abusive, taking their children, handing them over to another human being for sex trafficking. So if this is a situation where the family courts come in, this whole thing could be viewed completely different. A lot of people could get mandated to go to therapy for treatment. A lot of people can get mandated to go in up under medication. And literally, we'd be helping a large portion of these girls. And R. Kelly himself will get the help that he so badly needs. But to take this case and to bring it into a court of law, to try him under the fact that he's sane, when in fact he might not be balanced mentally, that has to also be proven too. But I will say that some of you might have been engaged in court hearings, and some of you might know a little bit more than I know about the situation. And you've seen court cases become overthrown and things thrown out. But we must understand that cases fall apart when people stop their lying. Cases can fall apart when people no longer want to cooperate and they get angry and their so-called friend is not their friend anymore. Now they want to tell it all. So then the court has more and more cases to hear, and it then becomes a subject of family law. And if this is the case, then maybe some of these people will get the therapeutic help that they need, especially R. Kelly and all of the girls and their parents involved. Because there's certainly a ring of circus here that needs to be addressed by family law. And it needs to be addressed by co-parenting, because apparently there was some problems there in parenting these girls, and it was an effort to hand them over to R. Kelly. So I think personally, if the family child development would come into the picture, talk to the mothers, because there's going to be some repercussions when these girls have to go back home. They are now women and they don't want to listen to mother, and they are pretty much calling the shots. So how do you force a young girl to go back home without her having retaliation? But cases do fall apart. Resolutions, family law, and family law can be expediently administered to help all who are involved, the mother, the father, and the young girl. And R. Kelly can get off lightly by going for therapeutic help and getting the assistance that he is so badly needing. And I think if we think about this, let's put ourselves in this family situation, because we don't want to see families go to jail. And a large portion of these families might be subject to some perjury, and some of the girls as well. So the best that we can hope for out of this whole situation is that family law come into the picture and they judge accordingly and get them the therapeutic help they need. And that's basically all I want to say on this topic. And I have been using my prior case to indicate that we all know something about what's going on. A lot of us have been involved in courtroom cases, and a lot of us have prevailed, and a lot of us have come out ahead. And some of us, when the case fell apart, it affected us. But for those who are getting tried under false pretense and false lies, it's to your benefit to hope that the case falls apart, because it's to your favor to know that the other defendants' testimonies were false, and they cannot use misconduct over you anymore. And your name has to be cleared, and it has to be cleared openly, because they can damage and tarnish someone's name after they've been proven to be innocent, and they still go on as if nothing happened. There needs to be a public outcry about this, because if you do not come up front and tell the truth and the whole truth and nothing but the truth, you can damage someone's character in the community. And we certainly don't want that. And we want to thank you for joining us for this short little segment. I thought I'd come on this evening. And straight ahead and into the future, Odabo, Baba Booey to y'all.